Hi, everybody. Welcome to our first breakout panel of the day. This panel is on the subject of Council of Canadians with Disabilities, a case pertaining to public interest standing. I have to admit, when I received the phone call from a friend letting me know that this case was going up, that leave had been granted, my first reaction was, why? And then when I learned of the torrent of lawyers showing up with their clients to seek leave to intervene in the case, again, my reaction was, why? And then when I received a phone call from one of my clients asking me if I would represent them in an application for leave to intervene, pro bono, as it always is, I was like, why? Please, no, don't. And I tried to talk my way out of it, talk my client out of it. It didn't work. We ended up going, and it was actually a great joy to be in the court last January with so many competent counsel, including virtually everybody on this panel. And I know that one of our panelists, Ruby Dhand, is with us virtually, and she just gave us a little wave. So let me introduce the panel so we can get into discussing this case. To my immediate right is Gerard Kennedy, an assistant professor at Robson Hall, University of Manitoba Law School. He teaches and researches in the area of access to justice and rule of law, and he is here as a true commentator. He was not involved in the litigation. Beside him is Elin Sigurdson, Vancouver-based lawyer practicing constitutional law and Aboriginal law with the firm Mandell, Pinder, and she represented the British Columbia Civil Liberties Association as an intervener in the case. And finally, our last speakers are a team consisting of Karen Spector, who's sitting right to Elin, to the right of Elin. She's a mental health lawyer practicing in Ontario, based here in Toronto. Beside her is Tess Sheldon, also a mental health lawyer and assistant professor at University of Windsor Faculty of Law, where she teaches and researches on law and psychiatry, disability rights, and access to justice. And finally, our other disability lawyer, Ruby Dhand, who's also a professor of law at Thompson Rivers University, and who also researches and teaches on disability and access to justice. So with that expert panel lined up, I want to turn immediately to Gerard to give us an introduction and overview of the case, and then we'll proceed with some analysis from our other panelists. Gerard.
Well, thank you very much, Faisal, for that kind introduction. It's really an honor to be here today at this conference where I see so many friends and mentors and influences. I feel like a bit of an interloper, the only non-counsel who is somehow on this panel. So hopefully, as an observer, I can give you a bit of an overview of the case and how it changes, or I would posit not really, the law of standing, and what it says about procedure in constitutional litigation in particular, but just more generally going forward. Now, standing is a civil procedure doctrine that is really designed to discourage litigation by intermeddlers. We don't want busybodies clogging up the court system. Now, this doctrine must have evolved for a reason. If I and, I don't know, someone named Tom have a contract and I breach the contract, and then someone who has nothing to do with it decides to sue me over it, well, that's not really appropriate. My view of the matter, or Tom's view of the matter, should be viewed as dispositive. That makes a lot of sense when we're talking about traditional private law litigation. But when we're talking about constitutionality of statutes, we also care a lot about knowing that laws are actually constitutional. And we also note that many individuals who find themselves on the sharp end of unconstitutional law have real difficulty navigating the court system. So 10 years ago, in downtown Eastside Sex Workers United Against Violence Society, Justice Cromwell wrote, for unanimous court, there are three factors, I'll get into them shortly, that you can grant public interest standing generally, but particularly to challenge the constitutionality of government action. Now, One would have thought that this could be resolving a lot of matters. And yet, in Council of Canadians with Disabilities, we see perhaps some reminder is necessary. This was a claim brought by the Council of Canadians with Disabilities, a well-known advocacy group for those with disabilities, alleging that BC legislation that permitted involuntary medical treatment of those with certain psychiatric conditions offended Section 7 and 15 of the Charter, discrimination on the basis of disability, and rights to security of the person. After 13 months of litigation, however, the two individual plaintiffs withdraw. That's important. We're going to come back to that, leaving only the council, which, being a non-individual, can't be subject to involuntary medical treatment. So the Attorney General of BC brings a motion to say the council has no standing, strike the claim. The Supreme Court of BC denies public interest standing. The BC Court of Appeal overturns that, holds that this is clearly not complied with the spirit of downtown East Side sex workers, as Faisal may have suggested. Well, so why is that just not the end of the matter? Although, somewhat interestingly, the BC Court of Appeal remitted the matter back to the trial court to consider whether to grant public interest standing, largely because it wanted fresh consideration of how alternate litigation could raise the issues. So the Supreme Court grants leave to the Attorney General to appeal to the Supreme Court, and also allows the council to cross appeal on the remedy. And the appeal is dismissed, but the cross appeal is allowed. Chief Justice Wagner writes, just like Justice Cromwell did a decade earlier, for unanimous Supreme Court. And he reminds us that there are three factors that Downtown East Side says should be considered in granting public interest standing. And he identifies errors with all of them in the trial court decision. The trial court held there was not a serious justiciable issue raised because the council hadn't assembled a factual record. Now, that is simply not relevant at a pleadings motion and deciding whether to grant public interest standing. A serious justiciable issue is found if facts are pled that, if true, would amount to a claim, and that was the case here. Whether the facts have been identified could be relevant in the third stage, but we'll come back to that. The trial judge also queried whether the council met the second stage, which asks whether a genuine interest is had by the prospective litigant. Trial judge pointed out that council's expertise is mostly in defending and representing those with physical disabilities, not mental disabilities. Chief Justice held it's inappropriate to distinguish between the two. Disabilities or disabilities. And it was also held that the third factor, considering whether this was a reasonable way to prosecute the claim, wasn't adequately considered. Excessive weight was attended to the desirability of an individual plaintiff. And much like the BC Court of Appeal held, Supreme Court held there was a lack of consideration of the flexibility and practicality that has been Downtown East Side said should infuse the analysis of public interest standing. Chief Justice Wagner also held the BC Court of Appeal erred in remitting the matter, partially because it didn't consider whether any of the errors in the Supreme Court were overriding, because standing determinations are entitled to deference. And even though it was overheld here, BC Court of Appeal should have considered all of the factors, which are to be considered holistically, to determine whether the errors in the trial court were overriding. Before applying the factors on this case, the Chief Justice gives general guidance in how to consider this going forward. All of the factors are to be considered holistically. None of them is supposed to be determinative. This is to be considered against the purposes of standing law. We do want to prevent busybody litigation. We want to prevent crowding the courts, especially if there's alternative litigation. But we also need to bear in mind the difficulty that certain persons have in accessing the courts and the principle of legality. An individual co-plaintiff, all other things being equal, it's preferable, but it's really not required, and too much weight is not to be assigned to it. It is possible to revisit standing post-discovery if it's obvious the public interest litigant is unable to assemble a sufficient factual record. I think this is going to be very rare and exceptional, but it's theoretically possible. More importantly, Chief Justice Wagner noted, if the claim is obviously not going to succeed, there are other ways to resolve it. I'm going to come back to what they may be that don't involve the blunt instrument of denying standing, which results in no resolution of the claim on its merits. So how to apply these factors on this case? No difficulty in clearing the first stage. Clearly, facts were pled that, if true, would amount to Section 7 and Section 15 violations. Whether or not they could be justified under Section 1 or whether they could actually tender the facts, that's a question for the future. But easily a serious justiciable issue is read. It is unquestionable that the CCD has expertise in representing those with disabilities. It's not appropriate to parse physical and mental disabilities as the trial court did. And it's a reasonable way to bring the action forward. Guidance is given that in this third category, we're to consider 4 things. Does the public interest litigant have the capacity in terms of counsel and resources? Clearly, the counsel did, had excellent pro bono lawyers from McCarthy's. Would the claim actually be in the public interest and advance access to justice? No dispute that that was also met. Are there alternative means to bring the action to trial? I would think in the future, this is where public interest litigants could counter into more problems if there are going to be duplicative proceedings. For instance, there's one claim with a plaintiff standing as of right, another one with not. Here there was a class action that raised somewhat similar issues, but Chief Justice Wagner reminds us that that's not determinative. And it's really not determinative in this case, because the Attorney General of BC, despite asserting in this case that it was a preferable way to raise the issues, was nonetheless saying that the class action was statute barred in the class action and was opposing certification of the class action. Kind of dubious to be saying different things in different claims, but be that as it may. And lastly, does the public interest litigation have impacts on the rights of others? Is there anything analogous, for instance, to the breach of contract case I suggested earlier? In public interest litigation, particularly in constitutionality of statutes, that's unlikely to be the case, but you do want to make sure that competing points of view are raised. You weigh everything holistically. He granted public interest standing in this case, and pursuant to the Carter criteria, awarded full indemnity costs. If I have time, I might get back to that. What does this say for standing going forward? Fundamentally, I think this is a doubling down and a reminder of the criteria from Downtown East Side. But sometimes that reminder is very helpful. For instance, Ippley was a reminder of Gladue. Sometimes we need things like that. Standing exists for a reason, but so do principles of legality. Individuals can even exceptionally be granted public interest standing. That's more unusual, but we did see Ryan Alfred was granted public interest standing to challenge legislation that abrogated constitutional privileges when no one who was benefited from the privileges was incentivized to do it, and he won on the merits in the Superior Court. So there you go. More likely, however, we're going to be talking about charities or public interest advocacy groups that will step into the situations of individuals who have real difficulty accessing the courts, such as the sex workers in Downtown East Side or those with mental disabilities in Council of Canadians with Disabilities. And we also need to consider, we only need a litigation to be a reasonable and effective means to raise the issue. It doesn't have to be the only way, it doesn't have to be the theoretically best way, but it is a reasonable and effective means to raise the legal issues. I'd also posit, as I put my CivPro scholar cap on, that this is part of a general trend in civil procedure to resolve cases on their merits. Exceptionally, litigants will behave in such a way or have intermeddled in others' affairs that we have to dismiss claims without resolving on their merits. but we want them resolved on their merits, and we want them resolved relatively quickly. We've already seen this in the past decade in the Hryniak and Malden decision, which is a seminal access to justice decision, emphasizing the importance of such resolution on the merits, that also particularly commended the use of summary judgment in this regard. Motions to determine a legal question can also be used to resolve cases on their merits, as the Supreme Court noted a couple years ago in Atlantic Lottery. Wow, they're applauding me early. I have up there that a point of view, and I see Justice Sawson has stepped out. A case could be made that once you've decided a serious justiciable issue is raised, it might then be exceptionally inappropriate for the government to seek a determination on a question of law, having already passed that triage. That's maybe a tad simplistic, given that the downtown east side sex workers factors are to be raised holistically, but maybe there's some caution warranted there. But regardless, by using these other alternatives rather than a blunt instrument of denying standing, we see a development of the law and that there actually be law. There's of course no guarantee that the public interest litigant will win at the merits, but they shouldn't be struck out for a procedural defect unless it's really in the best interests of the justice system, such as obviously inappropriate litigation or interfering in the affairs of others, or just duplicative proceedings. Lastly, do I have time to talk about the cost order? Okay, very quickly, if I'm going to query this somewhat, this is another example where the Supreme Court ordered full indemnity costs, holding that the Carter criteria to award them were met. I'm actually going to say that I'm, as a CIPRO scholar, not completely convinced that this was more exceptional than most constitutional litigation. There was already ways to compensate pro bono counsel. I wonder if the elephant in the room here was that the Attorney General in BC behaved somewhat questionably in the litigation by causing a 6-year delay by challenging the standing, and then further taking contradictory positions in the class action and in the direct constitutional challenge, which is absolutely a reason to order full indemnity costs. And the Supreme Court didn't ultimately want to say that. You could also make an argument that public interest litigation, or even litigation generally, should always lead to full indemnity costs. Adil Abdullah recently wrote a very interesting article in that regard, but I'm not totally persuaded, given that McCarthy's was already going to get partial indemnity costs, that they really needed full indemnity costs lest the litigation could not have proceeded. There may have been other things going on. But anyways, hopefully that is a lay of the land, and I really look forward to turning it over to my co-panelists who live the case. Thank you very much.
All right. Well, thank you so much for having me. It's just an honor to get to be here and be among so many people who are leading thought in the area of constitutional law. And as a lowly litigator out there, kind of trying to do our best, it's wonderful to hear about how deeply people are thinking about the implications and the complexities of the cases that are being decided by the court. So I was involved in CTD for the BCCLA with my colleague Monique Pungrashish-Spire, and our intervention really focused on strengthening and maintaining the tests set out in downtown Eastside sex workers. And we were specifically focused on protecting the ability of organizations to advance appropriate public interest litigation. So on that theme, I'm going to focus on 2 or possibly 3 points to add to this discussion on CCD. And the first one I'm going to address is really the reason for and the importance of the change in the law that came from downtown Eastside sex workers. Because that's what we were there to protect. That's what we were fighting for. And the second one, which ended up sort of being the focus of the intervention, is essentially that public interest litigation is different, as Gerard has mentioned, than standard private civil litigation, and that the law doesn't call in those cases for an effective presumption against an organization having the role as a public interest litigant. And then if I have a minute at the end, I'll register a moment of skepticism too about the decision of the court to identify an error in the Court of Appeals reasons about giving weight to access to justice and the principle of legality. So turning to my first point, and this is where I emphasize that it was critical for the Supreme Court of Canada to hold the line and maintain the approach that we fought for, that Downtown Eastside sex workers fought for in that court, along with my colleagues for other interveners in that case who really affected a change in the law as a result of that case. And the approach that was won in SWAV, which Downtown Eastside sex workers we often refer to as SWAV, is a contextual, generous, purposive approach, and it's one that ensures that the courts understand that public interest litigation is viable and justiciable, and it is essential to the maintenance of our Constitution, particularly when it comes to the vindication of the rights of the most marginalized communities. And you'll hear more about that from my fellow panelists. It's also an approach that calls on courts to really understand the realities of litigation for litigants, not just for the people in the courtroom, but for the people who are advancing these claims, because those realities are not always clear on the other side of a judicial decision. So this case came about because sex workers in Vancouver who were engaged in what they referred to as street level sex work or survival sex work sought to challenge criminal code provisions that together and individually had the effect of making it dangerous to engage in sex work to the point that their lives, liberty, and security of the person were impaired. And it was advanced by an organization formed by and for sex workers working in these circumstances in Vancouver's Downtown East Side. And that organization was actually joined by an individual sex worker, Cheryl Kisselback, who was no longer working, but who had directly experienced the harms of the laws. And Canada challenged the standing of both, and the Supreme Court of Canada ultimately granted them both public interest standing. So there's another example of an individual having public interest standing. And in doing that, that's where the restatement of the test arose, importantly concluding that the third branch is looking for a reasonable and effective means of bringing litigation. And that generous and pragmatic approach that the court called for is one that asks to address the real circumstances of the specific case before the court. So not imagining some other case, but is this case one that's going to be able to be decided? So what about this case in particular caused there to be a change in the law of standing? Well, and I think this is a case of, compelling facts actually making good law. In that case, the evidence was that sex workers experienced harms to their lives and their security of the person because the criminal laws were preventing them from working together, working indoors, doing anything to make their lives more safe, causing them to become stigmatized, and causing them to be unable to access very basic safety protection, including from the police. And the plaintiffs argued that the people who were most adversely affected in those ways were not in a position to challenge those laws at the time they're affected by them, or really in an individual capacity given the nature of the ways that the laws work together. They required in that case an institutional or a governmental or an organizational plaintiff to stand for them. Otherwise, the case simply could not proceed. And this was for sort of two core reasons. First, these are individuals affected by multiple intersecting forms of marginalization. Being engaged in sex work being one of them, but experiencing numerous forms of disability, racialization, indigeneity, forms of other types of stigma that are perpetuated or that are imposed upon them. So they fear public reprisal and can't be part of a public proceeding necessarily. They fear other repercussions like the loss of access to children. So they're simply not in a position to be able to individually advance complex constitutional litigation and remain involved in doing that over years. Second, the nature of the case was one that didn't simply lend itself to a test case model, like in a case about a charge imposed against one person, because the essence of the case was that a number of provisions of the criminal code work together. And the Supreme Court of Canada ultimately understood these features of the case and looked at the appropriate test for public interest standing as being one that's pragmatic, realistic, and sensitive to the realities of the communities in question and the realities of litigation. And so because of its understanding of sort of the structural barriers faced by communities, the court was able to arrive at a subtle textual change in the test, but the idea that a case being the only way to address litigation was able to shift to, is this case in these circumstances a way to have an issue heard? So as I noted, the case is critical really because it reflects the realities of litigation that are lost sometimes in the bare articulation of principles or concepts. It's a process is hard, it's uncertain, it's stressful, and it's very public. And for litigants, including those in CCD, it is long. So people who are in vulnerable circumstances are not in a position to be able to do that on their own. And I think fundamentally, if courts don't realize the realities of litigation, we're not going to have access to justice. So this is kind of part of the messaging that has to continue in the conversations between litigants, counsel, and courts. So, the litigants in SWAV and in CCD don't set out to change the law of standing. That's not their project. They want to advance a challenge to laws that affect their lives. But in SWAV, both the plaintiffs and the legal teams that had advanced the case were happy with the result. And the plaintiffs had become very committed to the idea of access to justice and the idea of the importance of being able to get in the door of a courthouse for them and for people in similar sort of situations to them. And that goal for those claimants has borne out. Public interest standing has been used. The test in SWAV has been used by prisoners, single mothers, homeless people, drug users, now people experiencing different forms of disabilities. But with the new test, after SWAV came down, we had a couple of concerns about how it was going to develop. One of them was about the idea of whether there would be a heavier burden imposed on the sort of the first step of the test in the prima facie justiciable case. And that concern was somewhat borne out in terms of what the Attorney General argued in CCD. The other concern was around whether courts were going to apply kind of an unnecessarily rigid approach to assessing whether the party bringing the action had the capacity to do so, in terms of focusing on sort of resource issue like who the lawyers are that are involved, or where do they get their funding and things like that, which are that's not a kind of inquiry that a private litigant faces, like do you have the right lawyer on your team, whether or not you get into the courthouse door. And we were worried that, is a court going to require like a legal team like the one that we had established for SWAV in every public interest case? Like, do you have to have Joe Arvey? Do you have to have 5 rising stars of the British Columbia Bar before the court? Do you need a lawyer that's embedded in a legal organization that is part of the community being affected? And if that's the case, is it going to be realistic? Right? So it kind of goes back to looking at the actual realities and the practical problems of litigation, and whether that access to justice is going to be able to be met with that kind of standard. And that hasn't really so much been a factor as far as I've seen. So with that, I want to turn to my second point, which connects to the importance of SWAV, because that case really addresses the essential role of organizational plaintiffs in advancing public interest claims. And what I want to emphasize here is the point about how public interest litigation is different. Public interest standing, obviously is not for claims about private parties and their disputes. It's about prosecution of issues that affect groups, and really issues that affect us all, because what we're talking about essentially is the interpretation of the Charter, interpretation of fundamental rights that affect everybody. So if, Gerard and Tom have their dispute, they're going to sort things out or not, but the rest of us are not going to experience anything related to it. If somebody's equality rights in one case are interpreted in one way, that's going to affect all of us. So the things you look at when you're asking whether a claim is reasonable or effective have to be about the type of claim that's being advanced, given its nature, given its goals, its remedies. And that exercise has to really understand, I think, the fact that public interest litigation being systemic informs the whole inquiry. And so the law sometimes talks about systemic litigation in a number of ways. There's systemic issues. And the two key ways that I think this plays into the question of assessing public interest standing is, so first, a systemic claim can be systemic in the sense that it's challenging the effect of something on a group of people. The claim is looking for a remedy to address that kind of a harm. Something like systemic discrimination is a term that kind of describes that problem. And CCD is an example of that kind of case, right? It's a group experiencing the harms of a law because of the nature of who they are and how they fit into that system. And the BC Court of Appeal recognized that as a piece of systemic litigation. The other way that constitutional claims can be systemic is in the sense that they challenge a system of laws, right? They can challenge a number of laws that work together as a system and cause a harm, often to a group of people. And Downtown Eastside sex workers was also a systemic case in this way. As I said, it challenged a matrix of law that had together the effect of imposing burdens on people's safety. Both of those meanings, I think, relate to how the reasonableness and effectiveness standard has to be understood. In neither of those definitions of systemic, should there be any presumption against an organizational plaintiff, because those understandings of systemic animate the kind of case that has to be made out by a litigant in order to prove what you have to prove to get your remedy. And indeed, as we argued in Suave, some claims may only be able to be made out by a collective advancing a consolidated set of expert and lay evidence because of the nature of those types of harms. Now, so and Gerard has already ably described what the Attorney General of BC was trying to do, but in our and this is what the intervention from the BC CLA was trying to resist. Fortunately, the court in CCD rejected the Attorney General of BC's approach, which would have imposed restrictions that that we described as and identified as amounting to a presumption against an organization acting as a public interest plaintiff. BC would have required an organization to prove they're a proxy for an individual, or to have an explanation to be able to prove why they are not joined by an individual or have an individual on the claim. And BC would also have imposed a requirement on an organization to demonstrate specifically how it would make out its case at a preliminary stage. And we said this is not supported in Suave and would create kind of a new rebuttable presumption against public interest standing for organizations. And I will say that while the court in Suave did express a preference for individual plaintiffs, a preference does not justify a presumption against an organization, because sometimes that organization is the plaintiff that's going to be able to make out the claim that is proposed to the court. And so those new burdens by the province were rejected in favor of the principled, proposive, and flexible analysis that was required in Suave. And we also argued that these burdens were actually not necessary to address any kind of problem that's reflected in the real world of public interest litigation. And that in fact, they're counterproductive. BC had raised fears about plaintiffless litigation, cases without facts, but this is not what's happening in claims before the courts. Organizations are not spending their hard-earned resources and time advancing pointless claims that are unfounded in evidence. That is simply not, that's something that's happening, and it's simply not something that they have time to do. So this notion of a specter of busybodies, again, is something that had to be pushed back against in this case again. And we say that those types of factors would actually be counterproductive, looking at the actual reasonableness and effectiveness of systemic public interest claims. The experience in the law is the opposite. Cases brought by public interest organizations are effective. They assist the court with robust records, relatively efficient litigation that's not done in slices, and that meaningfully examines systemic unconstitutional effects of laws. And so, I mean, essentially to conclude, our pitch before the court was that public interest organizations facilitate the consolidation of the concerns of individuals, and this is a legitimate way to assess the reasonableness and effectiveness of a claim. The organizations try to vindicate the interests and the rights of their constituencies and the effects of the laws on real people. So they're not sort of a fictional plaintiff. They're operating in a space where the realities of litigation require intervention by a body or an entity that can consolidate those interests. And I think my time is up, so I really look forward to hearing from others, and I appreciate the opportunity. Thank you.
I'm gonna sit here. Thank you so much for having us. Tess, Ruby, and myself, we will be sharing our 15 minutes to address 3 points related to the CCD and BC case, but that look beyond it at its implications for access to justice for persons with disabilities. So it's looking forward a little bit as well as back. So I'm going to start with a discussion about the access to justice concerns that flow from the initial decision to deny CCD standing. Ruby is going to discuss the barriers to justice that are sown right into the seeds of the litigation, including the underlying legislation being challenged. And then Tess is going to discuss the ableist barriers that impact directly affected individuals from bringing these types of challenges, which creates the very need for public interest standing. So while we absolutely celebrate this decision of the Supreme Court, we argue that the legal tool of public interest standing is not a panacea to addressing the underlying barriers to access to justice for persons with disabilities. It's a necessary step, but it's not sufficient. All of us, Tess, myself, and Ruby, we're all counsel to interveners at the Supreme Court. Tess and I, and along with our colleague, Kelly Bryan, we represented the Mental Health Legal Committee, a group of lawyers who represent clients with mental health issues in Ontario. And then Ruby will talk about her role as counsel to an intervener. But it's been an important opportunity for us to reflect on this case, having been involved and ultimately with what the court decided. So one concerning argument that was relied upon by the lower court in the initial decision to deny standing that we want to sort of take up here was that CCD only weakly met the genuine interest test because its work focused primarily on persons with disabilities more broadly, and the court says particularly with physical disabilities, and not specifically persons with mental health disabilities. And so the judge was not persuaded that CCD's 40-year history of advocacy, disability-related advocacy, rendered it as an advocate for persons with mental health disabilities, implying that mental health disabilities are not disabilities. And this argument really raises serious access to justice issues for persons with mental health disabilities, because it basically denies them access to the legal protections under the Charter and under the Human Rights Codes, which protect disability, including mental health disability, as a ground of discrimination. So while this argument was strongly rejected by the Supreme Court, which found, and I'll quote at paragraph 85, the distinction between mental disabilities and disabilities is unhelpful and unfounded, and that, quote, mental disabilities are disabilities, we still think it's important to bring it and to highlight it, because it really does rely on common misperceptions and stereotypes regarding persons with mental health disabilities that seems to creep into other court decisions and just common understandings of law and disability. So the belief that mental health issues are not disabilities is embedded in ableist barriers, which rely on negative stereotypes that invoke a certain element of voluntariness that are not invoked with respect to other types of disabilities. So for example, persons with mental health issues could get better if they just tried harder, or that addiction is a matter of personal choice and moral blameworthiness. And when persons with mental health issues face these kinds of attitudes, they can internalize them, and the resulting stigma makes it difficult to self-identify or disclose their disability and to seek the accommodation because of the shame they are made to feel about their disability. And a further complication is that some persons with mental health issues and addictions don't identify as disabled and considered psychiatric labels as oppressive and a way to discredit their different perspectives. But we understand that in order to get the legal protections, one has to, fit their lived experience into the term disability, as that's the term in the legal category recognized under the Human Rights Code and Charter. But luckily, the law has evolved, where the Supreme Court has recognized a social model of disability as opposed to a medical model, where the law no longer considers disability as a defect or a deficiency or flaw in the person that needs to be treated or cured, but rather a person's disability is due to the social attitudes and structural barriers and lack of accommodation. And so a person's disability may have no limitations in everyday society other than these stereotypes and lack of accommodation. So to identify as a person with a disability is, in a legal sense, does not mean you have to accept that there's something wrong with you or that you seek when you seek protection under the Charter or the Code. So we are mindful of the hard-won struggle for disability rights, as the ground of disability was only included at the last minute under the Charter. And it's important to ensure that persons with mental health and addictions are not excluded from the full scope of legal protections available under human rights law and the Charter. And I will pass it on to Ruby.
Thank you so much, Karen. And thank you so much, everyone. I'm incredibly honored to be participating today. I'm speaking here from TRU Faculty of Law, and I acknowledge that my privilege claims space on the unceded and traditional First Nations territory belonging to the Secwepemc people. As Karen mentioned, I was also part of a team of counsel led by Anita Zaghetti on intervening on behalf of the Empowerment Council, which is representing the voices of collective community of mental health and addiction users. I'd like to talk about the access to justice barriers that infect this underlying legislation and the deemed consent provisions under the BC's Mental Health Act. So people with mental health disabilities here in BC experience multiple barriers to accessing justice when they're involuntarily detained under BC's Mental Health Act. The barriers to accessing justice, it's really important first off to recognize that they are intersectional. And it's important to highlight that they have a disproportionate adverse impact on Indigenous, racialized, and equity-seeking communities. I've been part of a number of projects and research looking at having done empirical research here in BC, suggesting that Indigenous and racialized people with mental health disabilities interacting with BC's mental health system have much higher rates of involuntary admission, a higher likelihood of misdiagnosis, barriers to accessing culturally appropriate treatment. They often experience a higher involuntary admission rate, a higher likelihood of being diagnosed with psychosis, and increased use of seclusion, restraint, and emergency psychiatric medication. In the mental health context, access to justice barriers experienced by Indigenous, racialized, and equity-seeking people with mental health disabilities are very complex. And factors such as colonialism, systemic racism, poverty, unemployment, separation from family and community support, sociocultural mental health stigmas, misdiagnosis, mistrust of the mental health system, and culturally appropriate care often define these experiences. Along with recognizing those intersectional access to justice barriers, it's also important to recognize that unlike other jurisdictions, here in BC, there is no publicly funded advice services, rights advice services, and supports available to people with mental health disabilities who are interacting with the deemed consent provisions under the Mental Health Act. In 2019, the BC Ombudsperson has recommended that BC create this type of service to increase access to justice pursuant to the Charter. However, the rights advice services and supports have yet to be implemented. And there are still a disparity of services in Indigenous, rural, and interior communities, especially here where I live in Kamloops. And it's those rights information or advice, even since there are no rights advice services, we also see people with mental health disabilities are much less likely to have their detention reviewed before the BC Mental Health Review Board, and they often do appear unrepresented. Lastly, it's important to recognize that even before COVID, BC was conducting telephone hearings for people with mental health disabilities who were appearing before the BC Mental Health Review Board. And many people with mental health disabilities then also continue to go unrepresented, as I mentioned, especially outside of Vancouver for those who are in rural, Indigenous, and interior communities. BC also has the third lowest per capita spending on legal aid amongst Canada's provinces, and there is a dearth of lawyers, unlike in Ontario, who really do specialize in mental health law and disability law. And collectively, these access to justice barriers have had a significant impact on people with mental health disabilities and addictions who are interacting with the deemed consent provisions in BC. So thank you so much for this opportunity. And I'm now going to pass it on to my wonderful colleague, Tess.
Thanks, Ruby. Amazing. So just to remind us, Karen spoke to you about the underlying access to justice concerns that flowed from the initial standing decision. And Ruby addressed the underlying sanus barriers that infected, in fact, the impugned legislation, the BC Mental Health Act. I'm now going to offer a word or two about the persistence of procedural and substantive barriers to accessing disability justice. So access and accessibility was and is a foundational concept for disabled people's movements to resist disability exclusion. And for sure, accessibility means more than formal or technical access. And indeed, it requires us to confront disabling structures and ableist standards. So the question there would be access to what? And in the same way, access to justice is more obviously than just bringing cases. And that's important because we know that the economic marginalization of people with disabilities interferes with their ability to bring cases, further aggravated by physical, environmental, and systemic barriers that they face to accessing and utilizing the justice system. These barriers result from power dynamics that are entrenched, sewn into legal processes. That also result from unequal access to the opportunity to shape the content of legal rules. So this kind of like broad and purposive interpretation of access and accessibility is supported by our international legal commitments, including pursuant to the UN Convention on the Rights of Persons with Disabilities. Article 13 of the CRPD requires effective access to justice in all legal proceedings. And in that way, using the word effective in all legal proceedings, it goes way beyond the UN International Covenant on Civil Political Rights. The idea of effective access in all legal proceedings is concerned with a society that fails people by erecting barriers to deny participation. The problem isn't with the person, but instead the society that chooses to erect those barriers. And like Karen said, the CRPD marked such a shift away from individual models, medical models, instead attending to the way in which disability is socially created or produced. Similarly, the human rights model of disability builds on that social model and understands that people with disabilities are entitled to the full spectrum of human rights. And indeed, the CRPD includes a breadth of protections. There are provisions about access to health, access to education, access to employment, mobility. So it requires states parties to protect access to those upstream resources that people with disabilities need to survive with dignity. But disabled litigants don't often have access to those upstream resources. And so that leads us to the question, what upstream resources could support disabled litigants to make their own litigation decisions? What barriers to effective access causes the need for public interest litigants in the first place? So in the context of the CCD case, what did Louise McLaren or DC need to continue with that litigation? It's hard to know exactly, we don't know, but we do know that people with disabilities are routinely denied access to accommodations in court, access to clear information about their case, are often without those upstream resources that they need to continue and sustain constitutional litigation. Those material deprivation of those resources force people into conditions that make them vulnerable to additional deprivations, including the removal of the opportunity to make their own decisions. And I think this is so important because people with disabilities have often had decisions made for them. Their incapacity is presumed. They're barred from making decisions about their own lives, including by public interest organizations, in air quotes there, even those with good intentions and with disabled persons' best interests in mind. But that's not the case here, as CCD was only included as a last resort. And in this case, the individual and collective interests coincided. And so just wrapping up, like Karen, there's no doubt that this decision is cause for celebration and will go a really long way. But like Karen said, also, public interest standing is certainly not a panacea. Formal access to court is necessary but not sufficient. For persons with disabilities, good process doesn't always lead to good outcomes. And that's because our legal systems are just so infected by those ableist, sanist, systemic biases about the place of disabled people in our communities. So the real answer is certainly elusive, but for sure requires upstream investments that eliminate the need for public interest litigants in the first place. And just a word too, that in the context of this case, those upstream investments would have eliminated the need for coercive interventions as per the BC Mental Health Act. That if people have what they need to survive with dignity, voluntary supports and services, they don't need psychiatric coercion. It eliminates the need for that. So with that, I'm gonna, that's our group effort to convince you that the BC the CCD case is all about access to justice, including in non-obvious ways.
Okay, thank you very much to our panelists. We're going to take a little bit of time from whatever comes next because I think we need it to discuss a little bit with our panelists. I'm going to ask our panelists to exercise restraint in responding to questions. If you would, please try to keep them short so we can get to as many questions as we can. I see a hand, a few hands. Okay, so then I will. I was going to ask a question, but let me just skip over that and get to some hands. Yeah, go ahead. I was going to start a little bit, a few rows in front of you, and then maybe come back to you next.
I'll be super quick. Deborah Parks from UBC. Thank you very much, everyone. I guess something that I don't know that you talked about other than Gerard mentioning the position taken by the AG of BC. These cases all come out of BC. And in fact, there's another case, I don't know if Elin, I'm sure, is aware, the Single Mothers Alliance of BC case, which had the same Chief Justice who decided CCD, and who then, after CCD came down from the Supreme Court, entertained and decided a motion by the provincial government of BC to dismiss a case on the basis of lack of public interest standing brought by the Single Mothers Alliance of Canada, challenging the lack of legal aid or the inadequacy of legal aid for in family law matters and its gendered harms. And you know, and he heard that case in August after this case came down. And I don't know if people have read the decision, but he still kind of clings to some of the very things that he reluctantly grants standing, but there's a real, I'm just wondering if what you all think about the kind of reluctance of some courts in particular to really accept public interest standing.
Well, I mean, I think that fundamentally the adversarial process has us all conditioned to have a view of a particular kind of litigation. And I think there's on the part of some just an unwillingness to conceive of the broader scope of a claim like that being advanced by someone who's not directly affected. And it might be simply just the way that we're kind of programmed and educated to understand what litigation is and does, and what remedies a court is competent to offer. But yeah, I think it's an ongoing growth, including for the Chief Justice in that case, who, you know, in CCD doesn't even really make much reference to SWAV. In Single Mothers Alliance then goes on to sort of actually maybe a little bit begrudgingly acknowledge that, okay, this is the test, I'm going to apply it, but I am going to wait and see what the record looks like, because later in the day, you know, it's open to you, Attorney General, to make your claim that in fact there was never standing. I don't know what the answer is, but that's what I think about that.
I'll just plant a flag in the sand that the assignment powers of Chief Justices should probably be the subject of future analysis, but I'll just say that.
Okay, let's go to another question. Yeah, go ahead.
Hi.
You're on.
Okay, great. My name is Olga Redko. I'm a litigator at a firm called IMK in Montreal, and we actually do a lot of public interest work involving public interest litigants with public interest standing. So I'm curious to get your views just on this very last point, the fact that in CCD, the court says, well, you know, it's okay to grant standing right now, but you can reconsider it later, which I found to be personally a very strange conclusion, something that kind of seems to come out of nowhere. Something that seems fundamentally at odds with the idea that if, you know, later down the line, either after the discovery process or even at trial, the plaintiff, whether an individual litigant or a public interest litigant, hasn't produced enough evidence to make their case, well, you know, the obvious thing for the court to do is to dismiss the claim. So I'm just curious to know your thoughts about, you know, where you think that apparent carve out came from and what you think the chances are of courts using it in the future, because for me, this is, I can tell you that for my clients, this was a very odd thing to read and something that I just have a hard time envisioning occurring in practice.
I also thought that was very odd. What I think might have been going in mind was, suppose after discovery, it is clear that the litigant that has been granted public interest standing has, for whatever personal reason, been unable to assemble a sufficient evidentiary record, and a court doesn't want to prejudice the case law by deciding on the merits that the claim should be dismissed. It will simply revoke the standing. and allow someone in the future to bring the claim. I share with you skepticism that that is actually going to be in practice, because odds are if the public interest litigant, that for the reasons that Elin has noted, is likely to be good at assembling the record, if it can't produce the record, the court should probably just dismiss the case. But maybe something unusual will have emerged in discovery. Like, that's my guess, but I agree with you, and I even mentioned it. I think it's an odd statement to have thrown in there.
Yeah, can I just add, I just have two quick thoughts about that. One is this idea of residual discretion has kind of been a theme in the standing cases. Like, I think back to Finley, I'm not sure if that's exactly the one, but about that time. And just the notion of it being this discretionary opportunity is just animates, like it's always there, it's always a question. You're not fully legitimate as a public interest standing plaintiff unless you've actually completed your case. So there's sort of a theme there. The other sort of element of that that we see is, and you've probably seen this in some of your cases too, is where a Crown will take a position, oh, we're just trying to help you out by making this application at an early stage, save you all your money and your energy for your, the good work you can do over there for your community by, making sure that, you really genuinely have standing now. And because we could always ask for the order later. So there, there's just kind of this constant threat in there.
I just want to say also one thing is to think about the timing of, I think it was the court was trying to signal sort of something about the timing of when the AGBC did raise the standing issue and whether it was appropriate to have raised it so early in the litigation. And so I think that the timing is a question that needs to be thought through as well.
Okay, it's with great disappointment that I draw this panel to a conclusion, but I think we're moving on to lunch. So thanks for being here, and keep the discussion going. And our panelists will be at lunch, so find them.